We're about ready for our final panel this afternoon on litigating Brady, games prosecutors play to avoid compliance. And we have four speakers here. Since we have four and this is the last session, let me try to keep the introductions short. Our opening speaker is Bennett Gershman, a constitutional law and criminal procedure specialist coming to us from Pace Law School. I actually got to know him as a First Amendment scholar, but he's done a lot of work in this area, and he'll start us out. Then we will be followed in order by my colleague Mike Benza, who is also my former student, and we have agreed not to tell stories about each other. But Mike has done a lot of criminal litigation, a lot of death penalty litigation, and he'll be followed by Alafair Burke from Hofstra, who has written extensively in this area, and will be and our cleanup hitter here will be John Lewis, who is a partner at Jones Day, and in addition to a lot of commercial litigation that he's done, he has also done some significant death penalty work, including one case from a couple of years ago that he won 8-1 in the U.S. Supreme Court, Wilkinson against Dotson. With that, let me turn things over to Bennett, and we'll get the session underway.
Okay, thank you, Jonathan. First, I really would love to thank Steve Day and his colleagues on the Case Law Review for putting together this important program. I know how much work they have to put in to do something like this, and I'm sure it's going to be time very, very well spent. Also, just needless to say, the people on these panels that you've seen are among the most impressive people in academia and the profession dealing with subjects in criminal procedure, and Brady in particular. I read their articles, and I just can't wait to meet them, and they're heroes. And I just want to say one more thing. As you think about who are the great people today, the great people, you think about somebody who's been convicted of a crime they didn't commit, spends 12 or 2 millennia in jail. There was a young man in my county, Westchester, just recently exonerated by Barry and his people, who was convicted of a murder when he was 16 years old. He spent 17 years in jail, more than his entire lifetime. When he was convicted, was spent in jail. It just strikes me that if there was like a Nobel Prize for contributions to humanity, I mean, Barry Scheck and Peter Neufeld, I can't think of anybody today who's done more great things than they've done. Just freeing somebody who's been wrongfully convicted. Anyway, I just wanted to say that. I've been writing about prosecutorial misconduct for a long time. I was a prosecutor in New York City for 10 years. And I guess I've been thinking about Brady for 40 years. When you think about it, as a prosecutor, as a criminal defense lawyer, as an academic, as a consultant, involved in lots of civil rights cases involving Brady violations. Brady is one of those cases that you just can never really fully understand or fully be able to kind of describe and talk about. It's just so frustrating and so hard to get into. I wrote an article just published in South Texas Law Review. You have it in your stuff here, where I tried to reflect on the last 42 years of Brady v. Maryland, and I talk about the elements of the holding and how the courts have basically dissolved the rule, how the judiciary has mangled it, how the prosecutors have subverted it, how the bar associations have avoided any type of meaningful discipline. I propose a couple of ideas, but I really don't think there's any way of solving or remedying Brady. I think Brady is a rule that's impossible to enforce, and I don't think there's going to be any meaningful remedy, whether it's education or monetary incentives or statutory proposals or, it just strikes me that that Brady is part of our adversary system. And once you start thinking about our adversary system, and you start thinking about the civil adversary system and how lawyers play games, then you sort of translate that into the criminal adversary system. And that was my title. Steve took my title as the title of this panel discussion. I thought, games people play, right? This is games prosecutors play to avoid compliance with Brady. And I tried to describe the way Brady is litigated from beginning to end. Now, I don't know, I know there are some judges here. There were. I know there are lawyers, criminal defense lawyers, and academic. Raise your hand if you're a prosecutor. Oh, wow. I didn't expect to see one. My. Welcome. I'm surprised. Okay, because I figured two prosecutors. All right. Because I like prosecutors. I mean, people think I don't, but I really do. And I think most prosecutors are fair-minded people. I think Brady is a rule that cannot be meaningfully enforced. Sometimes because prosecutors willfully don't comply, and sometimes because prosecutors just don't know whether there is hidden materials out there that they're just not aware of. I mean, I'll make you a bet that there is that a huge amount of Brady evidence is out there in government offices, in the file cabinets, in the boxes, in the drawers, that we don't know anything about, we'll never know anything about. And everybody knows this. Brady evidence is rarely found years later. The cases we read about are the tip of the iceberg. When you think about the adversary system, you realize right away that Brady is so counterintuitive that it just can't work. I mean, here a prosecutor is supposed to say, I want to prosecute this defendant and convict this defendant because I know he's guilty, and yet I got to give the defendant information that's going to be able to help him get off. Is that likely? Do lawyers really think like that? I mean, certainly in the civil system they don't think like that because they don't have to, but the prosecutor is a minister of justice, and the prosecutor is supposed to serve the cause of justice by Brady disclosing evidence that is material to guilt or punishment. In thinking about what I could say today, I felt it's all been said. You've got some terrific jurisprudence on Brady and plea bargaining, Kevin and John. And you've got a lot of discussion on the prosecutor's mindset, Alafair and others writing about tunnel vision and cognitive biases that prosecutors really see, they're in a state of denial. They see the defendant's guilty, and anything that contradicts that theory is obviously not exculpatory. It's not information that the defendant should get. It's just not believable, and so they put it aside. This idea of tunnel vision. I was saying to myself, well, I'm in Cleveland. Maybe I could say something about Cleveland District Attorney's, Cuyahoga County District Attorney's Office. And I pulled about 200 or 300 cases from that hometown hero, Carmen Moreno. And I hear apparently there's an award each year for the famous top DA, the Carmen Moreno Award. The Center for Public Integrity did a job on Carmen Moreno a few years ago. He's probably one of the worst prosecutors ever prosecuting in America. At least if you read the Sixth Circuit and you read a bunch of his cases, it's unbelievable what he's done and how he's been able to get away with it. And if there are judges here, congratulations. You let this guy spend 25 years as one of the worst prosecutors around. He prosecuted a lot of guilty people. Yeah, I know that. He also sent some innocent people to the electric chair. Close. I mean, D'Ambrosio and Larkins, maybe but they were convicted of capital murder, and convicted because he hid evidence that would have shown, I think, their innocence. So the world, but I didn't want to say that in the group from Cleveland. I'm a guest of you. I don't want to, So then I thought, I had this idea that the prosecutor is an ostrich. Because the whole thing about Brady is knowledge. What knowledge that the prosecutor has, knowledge that the defense doesn't have. That's what Brady's all about. Their respective levels of knowledge. And those of you who study, you've all studied criminal law, many of you are lawyers. You remember that famous instruction in criminal law, the ostrich instruction, which goes to kind of like the mens rea. I didn't know, says the criminal defendant, when the drugs are in the bottom of his car. I didn't know they were there. And the ostrich instruction is you can't say, you can't bury your head in the sand. You can't be an ostrich and say, I didn't know, when it's staring you right in the face. Kind of like contrived ignorance. And I'm thinking about, that's what the prosecutor does a lot of the time. I didn't know. It was maybe some other agency had the information. Or I didn't know that Joyce Gilchrist or all of those scientists that Barry Scheck was talking about, I didn't know they were junk scientists and frauds and dishonorable people. I didn't know that. I thought they were really good scientists. Or the jailhouse snitches. I didn't know that they're lying. I mean, these are upstanding. They're coming in and they're testifying, and I didn't know. And so so that was the idea. The prosecutor as an ostrich, and then sort of like the fox and the ostrich. The prosecutor is a fox, and then he's an ostrich. And then I kind of thought, maybe could I create a parable, like the fox and the ostrich, and then move into but I couldn't think. I spent a week, Steve, believe it, trying to think of it. I couldn't think of a parable for the fox and the ostrich. So then I moved on to, what prosecutors think about when they think about Brady, parenthesis, if they think about it at all. And because the funny thing about Brady is nobody here really knows, unless you've been a prosecutor, and I was a prosecutor, and some of you have been, you don't really know what goes on in a prosecutor's mind when they're thinking about Brady, when they're thinking about, is this evidence helpful or advantageous or favorable to the defense? What do they really think about? Sometimes we get glimpses. In the article you've got here, I said in footnote number 24, a survey that we did, my clinic in my law school. We sent out a survey to the prosecutors in New York State. We gave them a domestic violence case where the defendant is charged with beating up his girlfriend, assault, aggravated harassment, menacing. And these questionnaires are sent out. We got a bunch of responses because we asked this question: is this Brady evidence? The complaining witness, in other words, do you have to give this to the defendant? The complaining witness says, it was all my fault. 12 prosecutors said it was Brady. 12 said it was not Brady. I instigated the whole encounter. 10 said it was Brady. 13 said it was not Brady. I made him hit me. 12 said it was Brady. 12 said it was not Brady. He didn't hurt me. 23 said it was Brady. 7 said it was not Brady. I hit him too. 14 said it was Brady. 14 said it was not Brady. I exaggerated what happened. 18 said it was Brady. 10 said it was not Brady. What's in the police report isn't true. 23 said it. What's in the police report isn't true. 23 said it was Brady. 3 said it was not Brady. 3 prosecutors. I mean, where do these prosecutors come from? Are they really prosecutors? Or are they, they hangmen or something? What's going on here? It seems to me, it just seems to me that prosecutors are playing games. They're playing games. They're playing litigation games. Right through the whole phase of the litigation involving Brady. I'm just going to tell you something about these games. We heard this morning, open file discovery. Wow. The prosecutor is opening his file to the defense. You have it all. Take it all. Wow, that prosecutor's great. He's a great prosecutor, right? I mean, doesn't that sound like you're getting everything? Any criminal defense lawyers here think that open file discovery really means you're getting everything? You know, you're getting what the prosecutor is putting in the open file. You know? By the way, this wonderful prosecutor down in North Carolina, Nifong, he practices open file discovery. Carmen Moreno, open file discovery. Let me tell you his open file discovery plan. I say it in my manuscript for this thing, but here's what he does. Moreno's practice was to open his files to the inspection and discovery by the defense. According to testimony of defense lawyers, Moreno's custom was to have his colleagues lead members of the defense team into the prosecutor's office to allow defense counsel to look at the file. Under this arrangement, the defense was not permitted to physically view the police reports. No, God forbid, you can't look at them. A prosecutor read the reports to the defense lawyers. But as you can see from several of the cases, open file meant that so much evidence is hidden. You know, some prosecutors will practice open file discovery. I'm giving you 15 boxes of information. These are 15 boxes of my files. Take it. It's not indexed. It may be that in one of these boxes, if you look very closely, if you have 200 hours to go through these files, you might find some Brady information in one of these boxes hidden at the bottom somewhere, maybe. Prosecutors do that. That's one of the games they play. You know, in the Enron case, I mean, they were like, I don't know, something like 32 million documents. And they put the defense lawyers in a room with all the, you know, have fun. Take the afternoon to look through the file. You know, that's open file discovery. You know, and many prosecutors will say, you know, open file discovery is discovery. This is the material. Because remember, there's a difference between discovery and disclosure under Brady. Discovery follows statutes. You are required to disclose under Federal Rule 16 or local statutes certain kinds of information, which is usually required to be disclosed at a certain time. But Brady is not required. Brady isn't a discovery rule. In fact, you know, when I was listening to the plea bargaining discussion this morning, you know, there is no time when Brady must be disclosed. The Supreme Court has never said Brady must be disclosed pre-trial, for example. Brady is not a pre-trial disclosure rule. Brady must be disclosed in time to give the defense a meaningful opportunity to use the information. So what does that mean in terms of plea bargaining? It means to me that they'll never disclose Brady in plea bargaining. They don't have to. As I see it, they just have to disclose it when, and so if the defendant goes to trial at some point, they have to disclose it before trial or during trial. And so prosecutors who delay and delay and delay will win. That's one of the games. And rarely will a court hold that the delay in discovery violated Brady. Even discovery that's disclosed during the trial. Because, look, defense counsel asked for continuance. You didn't ask for continuance? You're basically saying it wasn't that important to me, right? I mean, that's, so there are a couple of cases, a couple of courts. I have to say the judges in these courts really seem to know about the burdens that a defense attorney faces. You're preparing your case for trial. You know what your resources are in terms of time, and you've got a theory. You got your theory and you're ready to go. And then 2 days before the start of the trial, the prosecutor puts on your desk this hugely important statement from a witness that totally eviscerates your theory. What are you going to do? How can you incorporate this into your theory? You can't do it. And so the case of Lica versus Portuondo is a wonderful case from the Second Circuit on the perils, the burdens, and how the court was really sensitive to that. But you're not going to find many cases like that. Most of the time, the court is going to say the defendant, you know, it's almost like rote language. The defendant didn't receive the Brady information at a time when he was able to meaningfully use it at trial, present his evidence, and so on. So, you know, the delay is one of those games that I talk about. Open file discovery is one of those games. I call it, what do I call it? Scavenger hunt. That's my game, you know. Charades. Prosecutors love to play charades, pretenses, disguises. One of the charades, we talked about it this morning, the tacit agreement. A wink, a nod, I'm not going to make any agreements. You just go on and testify, and then after you testify, I'll reward you. I mean, the prosecutor doesn't even say that, but it's sort of unspoken. Some prosecutors go even further than that. They have the witness they really want to have testify who's going to be critical for them. They say to this witness's lawyer, I will give you a deal, but I don't want you to tell your client who's going to be the government witness. Don't tell him. I'm going to make a deal, but don't you tell your client, so that he can get on the witness stand and say, truthfully, I swear no deal was made. Right? Just think about it. In other words, the prosecutor wants this witness to testify. It's a key witness, but doesn't want this witness to have to own up to a deal, because then is going to be discredited. So the prosecutor says to this witness's lawyer, an accomplice, or, a cooperator, I don't want, I'm going to make a deal. I'm going to make a deal with you, but I don't want you to tell him. So the witness gets on the stand. The witness says, no deal was made, and then the prosecutor after that. I mean, this Hayes against, Hayes against Brown, the Ninth Circuit came down so hard on the prosecutor in this case. And we had a case in New York like this, People against Stedman. I mean, this is dastardly when you think about it. And you wonder how often this happens. This is even worse than the tacit agreement. When prosecutor says to the defendant, this is case Silva versus Brown, the witness is a little bit incompetent. He's a prosecution witness, but the prosecutor says to this witness's lawyer, listen, I don't want him to take a competency test yet. I want him to testify first, then afterwards maybe, because obviously if he takes a competency test, it's gonna discredit his testimony. So wait until he testifies, then after he testifies, then you do whatever you want. The Ninth Circuit there found that was a Brady violation. One, because the prosecutor was hiding the competency issue, but also because the prosecutor was basically saying, I know my case is weak, and I don't want this witness to be, discredited by a competency test. This whole idea, of the prosecutor as the ostrich. Prosecutors don't want to know a lot of things. A prosecutor is charged with knowledge of other government agencies involved in the investigation. So that even if the prosecutor really doesn't know something that's in the police file, the prosecutor is impliedly, constructively charged with knowledge of that. But these are the agencies. Now here's my thinking. The prosecutor, even though he doesn't know, is charged with knowledge. But then the question becomes, how aggressive should a prosecutor be in searching for information in the police files or files of other government agencies? Do you have Brady evidence? I want all the exculpatory evidence you have. I have a constitutional obligation to give it to the defense. Give me everything you have, police. You think the prosecutor's going to do that? Or is the prosecutor going to simply wink and say, now, if you look at Great Britain has a very, very strict mandate for police, how they have to account for all of their files and disclose to the prosecutor specific information. I mean, but Britain is not the United States. And in Britain, the prosecutor has this duty, a very important duty, to learn about exculpatory, but we don't have that here. And if the agency isn't involved in the investigation, even though the prosecutor might know that there might be something in the Motor Vehicle Bureau or the Welfare Department or something like that, the prosecutor doesn't have to look for it. He really doesn't. Isn't that amazing? Even though he knows that there's something there that could very well be Brady material, he doesn't have to look for it. And case after case says it's an independent agency. It's not controlled by the prosecutor. The material is not in the prosecutor's possession, and therefore there is no obligation. What do I call that game? I don't know, hide and seek? I don't know, not sure. And then, of course, there's the other one, where if the defense knows about it, or should know about it, the prosecutor doesn't have an obligation to disclose. That's interesting. So in one case, there was a witness who testified for the prosecution. There was a lot of exculpatory stuff that the prosecutor didn't disclose. This witness, about 25 years ago, had been a client of the Legal Aid Society. You knew about that, didn't you? You knew about this witness. He was your client 25 years ago. What? The Legal Aid Society is supposed to go through their files for the last 25 years? So either you knew or you should have known. You should have known about this witness. or there's material in a public agency that could be subpoenaed. The prosecutor says, it's accessible to you. All you have to do is slap a subpoena on the agency. The only thing is, why would the lawyer even want to go to this agency? He doesn't even know anything about it. It's theoretically accessible in that the lawyer can, serve a subpoena, but the lawyer doesn't know to do that. But this is one of those games that the prosecutors play a lot. The idea is we don't want defense lawyers to sandbag the prosecutor. We don't want defense lawyers to first play ignorant and then later on say, prosecutor didn't give it to me. If the defense lawyer, that's the idea here. You don't want sandbagging. But in so many of these cases, the prosecutor is arguing the defense have access to it, they're available to them, they should have known about an affidavit that was just filed by one of my witnesses yesterday. How is the defense supposed to know that one of your witnesses just filed an affidavit in the court clerk's office? And then I guess in line with Peter Joy's terrific article in Wisconsin recently, everybody knows that many prosecutors, I'm not saying all prosecutors, many prosecutors zealously resist post-conviction claims of innocence. I don't want to know anything about it. I'm not going to do any DNA testing. Stay away from me. The case is over. Isn't that true? That's true. Some prosecutors say, all right, San Diego prosecutors, some prosecutors will go along with it. I'll do it. The prosecutor in Westchester County, terrific. She went along with the Discovic DNA testing, and it showed that he was innocent. But her predecessor, one of the real stars of the prosecutorial show, Janine Pirro, would have anything to do with it. I'm not going to do any testing. I don't care about it. He's been convicted. Forget about it. But in line with that resistance to claims of innocence, the way prosecutors use procedural obstacles, mazes, Simon Says, nomenclature, to avoid litigating Brady post-conviction. We're talking about a case where long after the conviction, the defendant has found dynamite Brady evidence. Assume that, okay? Assume that this evidence was not available to the defendant at his trial. He was convicted without this evidence. He found it. And now he wants to go to a court arguing constitutional violation. The prosecutor says, no way, you haven't complied with the procedural rules. You haven't shown cause for bringing this up 20 years later. I haven't shown cause. I didn't know about it 20 years later. How can I find it then? Too bad. If you read the case of Banks against Dreadkey, decided by the Supreme Court of California, that's a great case for seeing how a prosecutor in Texas is using procedural rules to keep a defendant from being able to litigate Brady post-conviction. It's pretty sad. The prosecutor says, you didn't say Giglio, you said Brady. Now, Brady, I think we know, includes Giglio. That's the way I always thought. But the prosecutor says, you didn't say the right words. You didn't say Simon Says. And therefore you can't make your claim. Now, the Supreme Court reversed the Fifth Circuit, which went along with the prosecutor. The Fifth Circuit it was not one of their great moments. But you go over, and so I guess I conclude when I think about the prosecutor is a zealous advocate. He's a virtuous prosecutor. He's this and that. He's also a gamesman. And that's my conclusion here. I had fun writing this article because it was, I can't say thinking about Brady is fun. Thinking about Brady is pretty depressing when you realize that Brady is probably the most pervasive and the most recurring form of prosecutorial misconduct, far more than anything else. It happens in so many more cases than we could ever be aware of. And as everybody said today, all day, there is no accountability. There is no accountability. Yes, I know Mr. Nifong is before the North Carolina State Grievance Committee. And by the way, that North Carolina body previously, a few years ago, cited a couple of prosecutors there for hiding Brady evidence. So it's not as if this is new for them. But you're not going to find this pretty much anywhere. It's one of the great travesties, scandals in our criminal justice system that prosecutors get away with it completely, totally. And it's pretty sad. I propose that Barry was talking about, the idea of having a special, like a prosecutor is sort of like a quasi-judicial official. We focus on judges. Every state has a judicial commission to investigate misconduct by judges. Why shouldn't we have a special commission to investigate misconduct? I'm not talking about by prosecutors. Now, I said that to him when he wrote his book, but he said politically we can't just say that. We have to say prosecutors and defense lawyers. Okay, say prosecutors and defense lawyers, but there should be something, some special commission that looks into misconduct. I also think, and this is totally pie in the sky, the way they do it in England, one day a prosecutor's sitting here, the next day the prosecutor's on the defense side, right? I mean, that's their system. I mean, it would be great if we had that here. We can't have it here. But if a prosecutor knew what the life of a defense lawyer is like, and I mean, he might be a little bit more giving and whatever. Okay, thank you.
All right, well, when I was asked to speak, I never actually imagined that I would ever be included in the company of the people that are here, because I'm a grunt. I'm out there working in the trenches. I do teach here at the law school, but the vast majority of what I do is representing people on death row in habeas cases, and this is, of course, the Brady area is a big area for us. But one of the things, when I saw Bennett's article and I knew what the way he was going to be presenting, I thought back to a comment that a number of my students have given me, which is that they hate sports analogies. There's a certain segment of the law school class who really just hates it when we talk about things in terms of sports. So I thought of a different way to try and reframe this a little bit. And so what I'm going to talk about is what we have here is the failure to communicate. We first have, this clip I'm going to show you now is the theory of Brady. All right, so here's our first set. This is the theory of Brady, right? We all have this idea. Brady says we're entitled to this, and so hey, can I get your files? Sure, and here they come. All right? This next clip, however, is, I think, more in line. This is the reality behind Brady. We were supposed to stop before that last part. My apologies to the FCC. That wasn't me. Okay? That second clip, for those of you who don't know, it's from In the Name of the Father. And what I didn't show you was this was like her 8th trip into the bowels of this old police station where the files were being kept. And it had started with this first clerk telling her that, well, of course, I will let you look at the files that I will let you look at, but of course, we don't want the IRA to get access to these files. Of course not. So he starts cleaning the files for her. She gets a new clerk who doesn't know what's going on, is simply trying to avoid doing his job. She forces him to do it, and so he brings her a file that he's not supposed to bring her. Now, it's even better, of course, because having had some Brady cases, I've actually never seen the file where I open it up and there is the comment that says, do not show to the defense. But, if prosecutors are going to cheat, they may be helpful to us down the road and highlight that for us. Now, we all know, of course, that Hollywood truly and accurately depicts what goes on in the world. So I thought I'd better have some somewhat real-world examples to bring to you. So this is a deposition of a case that's ongoing. It's actually, for those of you from Ohio know about the Lucasville Riot case from 1993. There are now several of those cases are in habeas, or 5 men sentenced to death. And there has been some discovery going on in these cases, and this is the deposition of the overarching prosecutors in charge of all of the prosecutions, or some, I forget how many number, hundreds of people who were prosecuted through these cases. And here's this deposition of the lead prosecutor. A question from the defense lawyer was there any overall Brady policy? No, it was just regular discovery rules. For example, there was always information that other people were involved. So if a witness would say, I saw so-and-so assault another person and didn't mention anyone else, that did not immediately jump out as evidence favorable, because a lot of these victims were assaulted multiple times by multiple people. Unless it was a situation where I saw this crime, the prosecutor saying I meaning the snitch, from start to finish, there was only one person that did it, and it was Steve, that would be different. So we would not, the fact that he did not identify someone, although he said it was a group of other people, and I don't know who they were, we would not consider that favorable, and therefore those statements and information was not turned over. So you have here a prosecutor who says, I'm going to comply with Brady. We sat down and said, we are going to comply with Brady. We had no special rules for Brady because, Brady's just a regular rule. But our theory of what Brady is is guided by the fact that, well, you know, we think these guys are guilty, and just because this snitch didn't say your guy did it doesn't mean that his statement is exculpatory. That, in fact, it has something to do with somebody else being guilty, but we're not going to turn it over. And what we know from these cases as we started to go through them, and in full disclosure, I represent one of these men who are on death row. I did not, this was not my cogent question that led to that discovery. It was another lawyer's. But one of the things that we've discovered is that they took literally thousands of statements in the course of the investigation, of which almost none were turned over to the defense. And you see here it's because the prosecutor's theory of Brady is something that is very different than what a defense attorney's theory of Brady would be. And I think that comes from, in part, and again, not being a former prosecutor, not having sat on the prosecutor's side of the aisle, I can't ever say I know what prosecutors think. I shake my head all the time. I don't know what they were thinking. And I can't imagine what they were thinking. But I think we get some insight. And here's a statement of a prosecutor's theory of crime that may give us some insight as to their theory surrounding Brady. As those of you know, Governor Strickland has recently issued reprieves for 3 upcoming executions here in the state of Ohio. His explanation was that the executions were set so close to his taking office that he was not able to give full consideration to clemency applications that had been submitted. When he announced this reprieve, Don White, who is the immediate past president of the Ohio Prosecuting Attorneys Association, said that the nature of Byros's crime should leave Strickland with little hesitation. A guy like that deserves cruel and unusual punishment. He needs to think about that. And that's the quote. The governor said he needs to think about clemency. Don White was, he needs to think about that? That scares me. All right, so here's what you have going on in the prosecutor's office as they're trying to figure out how to comply with Brady. And I think what we see is that the prosecutors actually think they are complying with Brady. It's just that they don't understand what the other side of the aisle is doing, just like the defense side doesn't understand their side. They don't understand the other side, so to them it's not Brady. And so they aren't, in most cases, intentionally hiding. I have doubts about some of these other situations, but that's the type of situation that you see coming up. And the reason that we have that, I think, is because you end up having no penalty associated with being wrong. There is no ramifications for a prosecutor when it comes to violating Brady, and there's a number of reasons why. Everybody had first-year criminal law. I had Professor Gianelli. Beat into us the idea of the theories behind criminal punishment, deterrence, retribution, the big one always, of course, being deterrence. You don't want to get caught because the punishment is going to be very high. Well, one of the theories of deterrence, of course, requires that you actually imagine getting caught. All right? So let's go through the levels of litigation and see where a prosecutor can ever imagine getting caught. Well, the first, of course, is discovery at trial. Well, we know that the prosecutors come in and say, we had open file discovery. We gave you everything. And the Supreme Court tells defense lawyers that when the prosecutor says they've given you everything, you should rely on that and expect that they have, in fact, given you everything, which explains some of the ineffective assistance of counsel I think that you see out there is when lawyers don't investigate, their response is, well, the prosecutor said he gave me everything. Who has to do any independent investigation? Well, okay, maybe not so much. But if that's what you're being told as a prosecutor, if you give him the file, you say you've complied with your duties, the defense attorney can rely on that. The defense attorney is going to do what? Immediately run out and investigate everything you've given and confirm and rebut? No, they know what they're going to do. And so there's no real threat of being caught at trial. But there's post-conviction. Some zealous, crazy, liberal defense lawyer will do this work for nothing and defend all these innocent people and do post-conviction petitions, all right? Well, if you've ever done any post-conviction work in Ohio, I have had the privilege of making some bad law, which has the effect of saying that there is absolutely no right to discovery in state post-conviction process. So in Ohio, you can file your post-conviction petition, and the first thing you'll do is file a request for discovery, and the motion will be denied at the same time they dismiss your petition, and your motion for discovery is denied because under Ohio law, there is no right to discovery. So you put in your post-conviction petition that says, I have a Brady violation, please give me discovery to prove my Brady violation. And the judge says, no, case denied because you didn't prove your Brady violation. All right? You then get to habeas. the federal courts, stacked with all of those liberals from the Reagan-Bush era and the new Bush era, well, they're giving discovery to everybody. You will get discovery. No, the attorney generals have learned there's this little thing out there called AEDPA, the Anti-Terrorism and Effective Death Penalty Act, and one of the things that the Anti-Terrorism Act did was significantly restrict the ability of the federal courts to give discovery. One of the things that you have to have done in order to get discovery in federal courts was to have basically gotten discovery in the state courts. So you get to the federal court and you say, federal court, please give me discovery. And the federal court says, did you do discovery in state court? And you say, no, I filed my motion. And they said no. And so, well, then you haven't shown good cause, and no, you don't get discovery. All right? And so you end up in the situation where there is no fear of actually getting caught because no court is ever ordering them to give you their files, to give you access to this material to find it. All right? Well, then somebody this morning mentioned the issue of public records. All right? A number of people have actually done public records requests and gotten materials. We used to be able to do this in Ohio. Again, as in the State Public Defender's Office, when we made this bad law, we were actually using public records to get files and finding exculpatory material, finding DNA tests, finding all kinds of wonderful things on behalf of our clients. And the prosecutors got tired of this. So what they would do is they wouldn't comply with the public records law. We would have to sue them. And the lower courts were always ordering them to turn over the files. Well, eventually a case got to the Ohio Supreme Court, and the Ohio Supreme Court said, you know, these defendants are getting these files, and they're getting their convictions overturned. This is not public records. This is attorney work product. And therefore it is shielded under Ohio public record law from disclosure through public records. Unless it's a drunk driving case, in which case mothers against drunk drivers can get the files. I don't know why, but apparently they give more money than the Criminal Defense Lawyers Association. All right, so you can get drunk driving files, you cannot get homicide files or other information. All right, on the off chance you somewhere along the way manage to find this information and get it into a court, as Bennett brought up the Banks versus Dreadkey case. Banks actually had inklings of the Brady material at trial and asked the prosecutor for the Brady material. There were a couple of snitches in the case, and he says, I want this snitch deals, I want their testimony, all this. And they said, no, we've given you everything, it's open file, you've got everything we have. So they go to trial, and the snitches come in, they lie their asses off, and then they go, and he gets sentenced to death, and the case goes up through the appeals. He gets in state post-conviction, he actually gets lawyers to represent him. They re-raise some of the issues regarding Brady. In the first case, in the first petition they filed, and they say, we think there's Brady material out there, but the prosecutor won't give it to us, so we can't prove it. And the state court says, well, yeah, you got to prove it before we'll give it to you, so go away. He then manages to get a couple lawyers who actually do things like leave their office and go out and investigate, and they find some information that sort of starts to corroborate that maybe there is Brady material out there. So they go back to the state courts, and they say, look, now we have affidavits that say there is Brady material. Please give us the Brady material. No, you should have come in earlier with that. So he goes to federal court, and he goes to the federal judge and says, federal judge, please give me discovery, because I've even got more information now through habeas stuff that indicates there's some Brady material. And the federal judge says, bizarrely enough, okay, and orders discovery. During the course of the discovery, and then actually at the evidentiary hearing, the police officer finally, after 15 or 20 years of litigation, admits that he had hid this evidence and he cut all these deals and did all this stuff. The Attorney General stands up and says, Your Honor, this claim is procedurally barred because they should have raised this at the initial trial. And the district court judge said, well, that sounds very interesting. And so he kicks the case. It goes to the Fifth Circuit. The Attorney General says to the Fifth Circuit, don't even look at this issue because it's defaulted. They should have raised it earlier. And the Fifth Circuit says, you're right, we're not even going to look at the issue. You should have raised it earlier. It gets to the Supreme Court, and the Supreme Court says, you've got to be kidding me. All right? And so for the first time, it takes him to go through state trial court, state post-conviction, direct appeals, post-conviction appeals, 2 levels of habeas review before a court finally says, you know what, state, you can't do this. You cannot hide the material and then turn around and blame the defendant for not having found it. All right? And so you finally see the court looking at a prosecutor and saying, you're going to get penalized because you're going to have to now go back and retry this guy for this capital offense 20 years after the fact because you hid this evidence. Now we know, of course, that this has a huge impact. We had a status conference on Monday in a federal capital prosecution here in Ohio. and the lawyers had filed a motion for discovery. In the federal system, the prosecutors are required to send a memorandum to Washington before they can prosecute a case as a capital case. They have to get permission from the Department of Justice to prosecute as a capital case. It's one of the controls that have been implemented to try and bring some systemic uniformity to federal capital crimes. So they have to send this memo. When the U.S. Attorney's Manual that says what they have to do in this memo, one of the things it has to say is you have to tell us in Washington about any exculpatory material. You have to tell us about impeachment material. You have to tell us why this case should be a capital case, but you also have to tell us why you don't think this maybe should be a capital case. Now, what does that sound like? It certainly sounds like Brady material. So we filed a motion in the case for the memorandum and all of the supporting evidence that was submitted, because, of course, they didn't give us the memo before you get to make your pitch. The U.S. attorney comes in and makes a pitch to the panel, then they set him down, and then they bring you in, and you get to make your pitch why it should be a life case, and then they throw you out, and then they send your guy for capital prosecution. So they didn't give us that memo before we made the pitch to Washington. But we asked for it after it had been certified for a capital case and said, look, this certainly looks like Brady. And there are a number of district courts that have agreed and said, yes, this is clearly Brady. The U.S. attorney in the case did not file an opposition to our motion, but at the status conference said, well, Judge, we think it's work product. Because I wrote the memo, and I'm a lawyer, and lawyers write work product, so it's work product. And we said, oh, Judge, that may very well be, but Brady doesn't say you can hide things by putting it in a memo and then calling it work product. Because when police go and talk to witnesses, that's work product, right? You take witness statements and put it in your file, it's work product. And the judge said, well, I'm not sure, that still might be work product. Then the Attorney General says, oh, but Judge, we've given them everything that we need to give them under Brady that we used in the memo, we gave to them in discovery. And you said, Judge, we don't know why they think this should be a capital, or not be a capital. Be mitigating. We don't know a bunch of these things. How do we know that they've given it to us? And the judge says, well, Mr. U.S. Attorney, if this case results in a conviction and a death sentence, the 2255 will come back to me, and if I find out it's Brady material, I will not be very happy. Motion for memorandum denied. Now, how are we ever supposed to prove that it was Brady material when he won't give us the memo to be able to show that, in fact, it was Brady material? And so you see here again a situation in which a prosecutor can make the decision not to turn over information without any fear of having any repercussions, which I think leads us to the one last result or situation before I conclude, and that is that following up on Bennett's comments about the games that the prosecutors will play, is you have prosecutors. This prosecutor whose statement, or the deposition I read, was also notorious for having the first capital case in the Sixth Circuit remanded for a new trial. The Sixth Circuit, if you litigate capital cases, will give you life sentences fairly regularly, but almost never will remand a case back for a whole new trial. In the first case in which they remanded for a new trial, it was based on Brady. And what was happening was in Hamilton County, which is Cincinnati, the police department had an operating procedure where they would create two files. There was the file that they would use to investigate a case, and then there was the file that they would give to the prosecutor once they decided who was guilty. And that was the file that the prosecutor then would give open file discovery. Here you go. Here's all the files I have. And in reversing that, in granting the writ, the defendant had actually been denied the writ in district court. The Sixth Circuit granted the writ and ordered a new trial. What they said was, well, the prosecutor could claim legitimately that he didn't know about this information. And we think that's okay, but it's really not the law. The Supreme Court says we have to follow that. So we grudgingly will follow that. But we do recognize that this practice has since been discontinued. And that the theory now is that in Hamilton County, the police don't keep two files. For those of you who work in Ohio and you've done any work in Cincinnati, you know very well that those two files still exist, and we're still not getting the original file. And I think that leads us then to somebody that Bennett has identified. I know that John's going to talk a little bit more about it, is Carmen Moreno. And Carmen is notorious for a number of different reasons, but one of them is his theory of prosecutorial misconduct, which is in fact what Brady is. And his theory is if you don't get reversed, it's not misconduct. This has been endorsed by the Cuyahoga County Prosecuting Attorney because they named the Prosecutor of the Year award the Carmen Moreno Award. In fact, one of the lawyers who just had another capital case being reversed was just given the Carmen Moreno Award, which seems somewhat ironic on a number of different levels to me. And I think then to wrap it up with my last analogy and my last reference to Hollywood, what we have with Brady is not the games people play, but crime and no punishment. So, thank you.
Hi, good afternoon. I'm going to try to go super fast, but I will stop and thank Steve and Liz, as everybody else has, and to say what a wonderful job you've done putting the event together. I'm very grateful to be here and for the invitation. I'm also grateful to Professor Gershman for the opportunity to have previewed his paper before the conference. It was thought-provoking and interesting, and quite frankly, the worst kind of paper to have to comment on because it's can't be disagreed with, right? It's bad to play hide and seek with Brady material. It's bad to play scavenger hunt. It's bad to play all of these games. So like a KG commentator that I am, rather than try to come up with something to criticize Professor Gershman for, I'm just going to change the topic. And instead of talking about the games prosecutors play to avoid compliance, I'm instead going to sort of flip that on its head and say, to focus on a different problem. Instead of talking about the problem that a lot of people have addressed today of purposeful Brady violations, of even ostrich-like willfully blind Brady violations, to instead talk about a problem that a lot of people have mentioned but not really explored, which is lots of prosecutors in good faith might wind up not turning over exculpatory evidence. And I want to explore those good faith prosecutors, the ones who are virtuous, trying to comply with their Brady obligations. And to use the analogy of games to explore that problem, I would say that what I'm exploring is not a game that prosecutors choose to play to avoid Brady, but instead a brain teaser that Brady itself forces prosecutors to engage in by its very standard. As many people have already mentioned today, and as we all know, the Brady standard itself incorporates this limitation of materiality. So when this notorious prosecutor that I never heard of before today says it's not misconduct if I don't get reversed, that's actually a sort of a defensible view. I wouldn't quite go that far, but it is true that it's not a Brady violation if he doesn't get reversed. And the reason for that is because, as we've discussed on a couple of the panels today, the Brady doctrine itself refuses to divorce the governing standard for prosecutors trying to decide, should I disclose this or not, from the standard that an appellate court should use in deciding whether or not to reverse the conviction if, in fact, the prosecutor decides not to disclose. Under Brady's materiality standard, the evidence is Brady material, a phrase that lots and lots of people have sort of been throwing around today, but it's only Brady material and therefore only required to be disclosed if there's some reasonable probability that if the evidence had been disclosed to the defense, the result of the proceeding would have been different. Put another way, would the evidence be such as to undermine our confidence in the end result? Moreover, materiality is determined with this sort of hindsight test. The prosecutor is supposed to compare the piece of exculpatory evidence against the rest of the evidence in the case, a case that hasn't been tried yet. Okay, so that basically requires the prosecutor who's trying to give literal compliance with Brady to first envision the trial. What do I think ultimately the evidence is going to look like once the case plays out? And then in step 2 of this brain teaser, they're supposed to hold up this piece of evidence at issue against everything else and say, okay, do I think that this piece of evidence at issue is such to undermine my confidence in a verdict I haven't gotten yet, a guilty verdict I haven't gotten yet. Okay. Now, what I want to talk about is how, when I talk about Brady as a brain teaser, the point I really want to make is, like all brain teasers, I assume some of us have tried to do some of those notorious brain teasers that like your 5-year-old kid can do immediately and you're sitting there trying to put the pieces together and for some reason can't do that, is because all good brain teasers prey upon common fallacies in human cognition that we all share. And what I want to talk about is how the Brady standard preys upon cognitive error that not just prosecutors, but everybody suffers from in a way that introduces not just random error into the system. Sometimes prosecutors undervalue materiality and sometimes they overvalue it. It's not random error, but rather Brady invites prosecutors systematically to undervalue the materiality of evidence. So to make that point, I first have to cover just a couple of points about cognitive bias and then bring it back to Brady. The first cognitive bias I want to talk about is confirmation bias. We've probably all heard that good scientists, right, are supposed to seek out information that would disprove their theory. That's the best way to try to prove your theory, is to first try to disprove it. And if you fail to disprove it, then maybe it's right. Instead, what we human beings tend to do is if we're asked to test a theory, we look only for evidence that confirms it. So in one famous study, researchers told their subjects to write out questions that they would ask a person to figure out if they were an extrovert, or the other half of the subjects were said, write down questions to determine whether or not this person you're talking to is an introvert. Well, those people who were trying to test for extroversion wrote down questions that would tend to only prove extroversion, never disprove it, like, so what do you do to liven up things at a party? Whereas those people who were looking for evidence of introversion would ask questions like, what is it about large groups that make you feel uncomfortable? Answers that were really only going to prove their operating theories, not disprove them. Importantly, there's also evidence of confirmation bias in recall. So when people are asked questions, when they're trying to test a theory and they're searching what they know from their own memories in order to test that theory, they pull up information in a biased manner. So in another well-known study, subjects were all shown a list of attributes for some hypothetical woman, and some of these attributes suggested that she was an extrovert, some suggested she was an introvert, and some were just sort of neutral. And then a couple of days later, all of these subjects were asked a question. Half of them were asked, do you think Jane would be a good real estate agent? And those half of the people tended to recall things about her that made her seem extroverted. Well, she struck up a conversation with a stranger, those kinds of things. The other half of the subjects who had been shown the same exact list of attributes about hypothetical Jane, when they were asked, oh, gee, do you think she'd make a good librarian? Like stereotypes about librarians, I suppose. But in any event, they would recall seemingly introverted facts, like she likes to take her coffee break by herself. So people pull up information that's stored in their brains in a biased way, depending on what their current hypothesis is. Before I can start getting back to Brady, I want to talk about one other cognitive bias real quickly, and this is selective information processing. This is the term used to describe people's tendency to evaluate evidence based on their existing beliefs rather than with neutrality. I'm sure if we don't recognize this in ourselves, we all know somebody that we've tried to disagree with, right? And they just can't depart from their existing beliefs. If you tell them something that's consistent with their existing belief, they go, oh yeah, that sounds right to me, I knew that. And if you point out some objective piece of evidence that contradicts their theory, they undermine it. They say, well, that must be made up, or that sounds junky to me, or that can't be right. And they just can't budge from their existing views. Well, that's selective information processing. So again, one well-known study, just as an example, subjects were all given contradictory empirical studies about the death penalty. One purporting to say that capital punishment was a deterrent against crime, one purporting to say it was no deterrent at all. Those subjects who walked into the room believing in capital punishment as good public policy thought that the study showing it was a deterrent was a really well-conducted study, it was very sound science, and the anti-capital punishment study, they said, well, gee, they really didn't have good enough controls, and we think the statistics were bad, and I don't like the format of the study. In contrast, those subjects who walked into the room opposed to the death penalty found all kinds of problems with the pro-capital punishment study, and had no problem at all with the it's not a deterrent study. Selective information processing. Okay, now here's where things get interesting. Look what happens when we apply we look at how these biases could play out when a prosecutor is engaged in Brady's brain teaser. Because let's assume for a second, right, prosecutors are human. The last time I checked, all the ones I knew, including me, were carbon-based. So if we know that if we know that people generally suffer from cognitive biases like confirmation bias and selective information processing, it's only natural to assume prosecutors fall prey to the same cognitive fallacies. And let's look at how Brady's brain teaser invites prosecutors to systematically undervalue materiality even when they're trying to comply. Okay, so let's take a simple example. Suppose a prosecutor with a robbery case with one defendant finds out that a critical eyewitness in the robbery case is a chronic alcoholic. I mean, she makes Lindsay Lohan look like a teetotaler. Okay, she's a chronic alcoholic, but the prosecutor really doesn't know whether or not the eyewitness was drunk on that particular night. She's just found out that she has a chronic drinking problem, but could well have been sober the night of the incident. And she still continues to believe that the witness got it right. Because, again, we're dealing with a virtuous prosecutor. If the information was such that the prosecutor herself believed that the defendant was innocent, our virtuous prosecutor would dismiss, right? Even if the prosecutor didn't shake her own personal doubt in guilt, even if she continued to think, I think I've got the right guy, this guy is guilty, but believed she couldn't prove the case anymore, if she thought the would-be exculpatory evidence actually would defeat her ability to prove the case, she would be forced to dismiss it or at least give some, rock-bottom plea deal to get this case, this doggy case, out of her docket, right, out of her file drawer. So now we're talking about a case where where the prosecutor still believes the defendant's guilty, still thinks she's got the right guy, and still plans to try the case, still thinks she can prove it. It's just a question of whether or not she's got to tell the defense attorney that her witness is a chronic alcoholic. Look at the steps she has to engage in. First, she's going to have to envision the trial. Well, what's the rest of the evidence against the defendant going to look like? Well, consider biased confirmatory recall. She's likely, as she's pulling up her memory about what the rest of the evidence against the defendant is, she's going to recall the fact that there's also another eyewitness, for example. He made some inculpatory admissions. That suggests he's guilty. He was found in possession of some of the robbery proceeds in a search incident to arrest. He looks pretty guilty. Also, on top of that, selective information processing comes into play. All of those pieces of evidence that suggests he's guilty, she's going to say, yeah, sounds right to me, sounds like very good evidence that he's guilty, that's why I still believe he's guilty. She's not likely to emphasize in her own analysis things that undermine her own case, that undermine her existing theory of guilt. So she might give short shrift or not even think, for example, of the fact that the defendant, along with his inculpatory admissions, also included partial denials, or that his statements were made under police pressure, or that he was not found in possession of some of the other robbery proceeds and there's no explanation for where those went. Or, she might not be thinking about problems with her other eyewitness. She's only going to be thinking about the things that suggest the defendant's guilt. So in short, she's going to overestimate the strength of her own case. And then on top of that, step 2 requires her to evaluate the exculpatory value of the evidence at issue in light of that now inflated description of the strength of her own case, and she's not likely to give it much seriousness, right? Okay, so her witness is a chronic alcoholic. So what? It doesn't mean she was drunk that night, and drunk people can still make good, accurate eyewitness IDs. She's going to conclude that it's not going to make a difference, and so she may very well decide not to turn it over. And that's not because she's trying to play games like hide and seek, not playing Simon Says, but she's trying to go through this brain teaser that Brady requires of her, but cognitive bias kicks in and can taint the process. I choose to emphasize this particular game, Brady's game, rather than prosecutors' games, for a couple of reasons. And one is I think it shapes the direction of reform. Rather than suggest, a lot of people today have suggested, well, prosecutors should be disciplined more, they should be disbarred more, they should be even prosecuted themselves for these kinds of things. But if I'm right, and that at least some of these problems are created when prosecutors unknowingly and unwittingly and accidentally fail to disclose material information, then upping the sanctions for purposeful violations is unlikely to change accidental behavior. Secondly, I choose to write in this area because I think rhetorically, providing an explanation for failures to disclose and other kinds of prosecutorial decision-making problems in a way that suggests that even virtuous prosecutors can depart from what we ideally might want from them is a way to fold prosecutors into the discussion. Because the problem is, if we only talk about those glaring purposeful violations, the blatant willful ones, even the ostrich-like prosecutorial problems, the prosecutors who took the time off from work to be here today are going to say, well, that's not me. I don't need to worry about these things. I don't violate Brady. I don't resist innocence claims. I would never do that. I'm out to do justice, without thinking that the problem could unwittingly fall on their desk, even though they're trying to do the right thing. So that's why I've kind of been doing work in this area. But I know time's running short, so I'm going to stop and turn the table over to John.
Well, I know we're running short, but first of all, thank you for even including me on this wonderful panel. And I have quite a job here following such an excellent group of speakers today. So I'm going to talk a few minutes about a case that I had. First of all, by day, I am a commercial litigator for a business law firm, Jones Day. But I believe that every lawyer has an obligation to do pro bono work. And luckily, Jones Day thinks the same. So I had an opportunity to represent a fellow named Joe D'Ambrosio. Joe right now is on death row in Ohio. But in early 2000, Joe filed a habeas petition with the Northern District of Ohio. Later on, my firm got involved in the case, and I got involved in the case. And last March, the federal district court judge granted a writ of habeas corpus, finding that the prosecutor in Joe's case had violated Brady and that Joe was entitled to a new trial. He's there still in prison because the case is currently on appeal. So the victory was bittersweet in a lot of ways. Certainly, we all felt very good as lawyers that we had prevailed in the case. But on another level, justice has failed us, whether Joe gets out of prison or not. Joe's been there for 20 years, and there's no question in this case, and I'm going to discuss some of the facts of the case, that the Brady rule was violated. And unfortunately, and I know we've had a lot of discussion today about the Brady rule and its requirements, but unfortunately, the type of enforcement that we utilize to win Joe the writ of habeas corpus is really not that good of an enforcement mechanism, because at the end of the day, whether we win or lose, and I think we will win and ultimately prevail, 20 or 25 years of Joe's life has been spent on death row. Let me talk a little bit about the case. D'Ambrosio was convicted of killing a fellow named Tony Clan, a young kid who at the time was sort of a guy who was trying to find his way, as a lot of kids were, down in the Coventry area. He was into some bad things, and one of the things that he was into was dealing drugs for some folks who lived down in that area. D'Ambrosio himself had only been in the area for a couple of weeks. He was honorably discharged from the military and had no criminal record before he was charged with Tony Clan's murder. But the prosecution's theory in the case was this: that D'Ambrosio and a couple of guys that he worked with, a fellow named Mike Keenan and another fellow named Eddie Espinoza, had a fight in a bar early one night. That fight included an argument with Tony Clan. A series of continuous events occurred that night which led the three, D'Ambrosio, Keenan, and Espinoza, to ultimately believe that some guy named Paul Lewis, no relation to me, had stolen drugs from Keenan. So they went looking for Paul Lewis. In looking for Paul Lewis, they find Tony Klan walking on the street after a night of partying at the bars. So they pick Tony Klan up and kidnap him in the pickup, according to the prosecution. Tony cannot help them find Paul Lewis. For some reason, they believe Tony could. And at the end of that night, because Tony could not help them find Paul Lewis, they drove him to Doan Creek, which, as some of you may know, is not far from here on MLK Boulevard. And they drove Tony to Doan Creek, and while Eddie Espinoza sat in the pickup truck, Mike Keenan and Joe took Tony Klan out to the banks of the creek and stabbed him to death and dumped him in the creek. That was the prosecution's theory, and it was based primarily on the testimony of three very important witnesses. One was Paul Lewis. Paul Lewis called the police the day after Tony was found dead with some suspiciously familiar information about the murder, including what Tony Klan was wearing. And he said that he believed he knew what happened to Tony Klan. So he came down and identified the body and steered the police to the folks that he told the police he thought committed the murder. And one of those individuals was Ed Espinoza. So the police, because of Paul Lewis's steering them in that direction, go to Eddie Espinoza's apartment and arrest him, and D'Ambrosio, and later Keenan, with murder of Tony Klan. Espinoza immediately implicates himself in some ways by saying that, yes, I was in the pickup truck and I saw those two guys kill Tony Klan on the banks of Doan Creek after a struggle. That was Espinoza's testimony. A detective, Detective Allen, Leo Allen, a well-respected detective in Cleveland, provided testimony about the investigation. And what was interesting is that Detective Allen didn't actually find Tony Klan's body. He wasn't the person who went to the scene. But the prosecutor in Joe's case convinced defense counsel that Detective Allen would testify for what those detectives who had found Tony Klan saw and would testify about. So there would only be the need for one detective at trial. Seemed like an open and shut case. Based upon the lack of any exculpatory evidence, and Joe's counsel filed a motion for Brady evidence, and the Espinoza statement was turned over, and the fact that he had corrected the dates on the statement. A three-judge panel, D'Ambrosio waived his right to a jury trial. Three-judge panel convicted D'Ambrosio of Tony Klan's murder and sentenced him to death. So that seemed to be a rather open and shut case. You've got a fellow who thought he knew something about the murder, directed police to the perpetrators, somebody rolled over as an eyewitness, and there you go, an open and shut case. During the pendency of Joe's habeas proceeding, actually a newspaper investigator, writer, got interested in Joe's case and did some poking around. And he figured a couple of things. One is he went and talked to the actual detectives who found Tony Klan's body. And they came forward and acknowledged that there was two detectives who found Tony Klan, both concluded at the time that they found the body that the murder had not occurred at Doan's Creek. They concluded this because there was absolutely no blood in the area, there were no signs of a struggle, and Tony Klan was neither wearing shoes nor had a wallet on him, suggesting that he had not been out that night at partying at bars, and they could find no shoes for Tony Klan. These detectives had concluded this at the time that they found Tony Klan's body. This newspaper writer wrote an article in Cleveland Scene magazine, of all magazines, and that sparked interest with D'Ambrosio's habeas counsel at the time. Shortly thereafter, Jones Day got involved. Luckily, we were in front of Judge O'Malley, who is actually one of the best judges that really the best federal district judges in the United States. And I say that not because she granted the writ in our case, but because she makes an informed decision about everything. And Judge O'Malley granted discovery in Joe's case. And in connection with that discovery order, we went over and looked at files from the Cleveland police and the prosecutor's office, and we discovered some interesting information. Number one, Paul Lewis. Paul Lewis had been previously prosecuted by Carmen Moreno. Why does that name ring a bell? Carmen Moreno also prosecuted Joe D'Ambrosio. Well, Paul Lewis had a rape charge against him. Here's the nature of the rape charge. Paul Lewis was alleged to have raped a young man who was Tony Klan's roommate. The only eyewitness to the rape other than the two, Paul Lewis and the young man, was Tony Klan. Paul Lewis spent approximately 3 months in jail on this charge. The young man missed the trial date, and so the charge was temporarily dismissed. Paul Lewis was released and recharged with that crime. While Paul Lewis was out on release, Tony Klan ends up dead. About a month after Paul Lewis helped the police investigation to Eddie Espinoza, Joe D'Ambrosio, Mike Keenan, that rape charge was dropped, never to be prosecuted again. That information was not turned over when Joe's counsel requested Brady evidence. In fact, Joe's co-defendant, Mike Keenan's counsel, specifically asked Carmen Moreno whether there was something to that rape charge of Paul Lewis. And Carmen Moreno said, no, there is not any connection between the cases whatsoever. Then we got to interview the police detectives who appeared on the scene first. And those police detectives told us that we told Detective Allen that we didn't think that the murder had occurred at Doan Creek. And we were pretty sure that it hadn't. Oh, by the way, when we were asking these police detectives about the policies of how they write the reports, the prosecutors came in and talked to the police detectives one time, and they told us not to put things in our report that might come back to bite us, such as conclusions about the murder. This is the testimony of retired police detectives. These two fellows, and I give them a lot of credit for coming forward and actually providing this truthful testimony, testified at the habeas evidentiary hearing. That was the second very key piece of Brady evidence not revealed and, in fact, affirmatively shielded from D'Ambrosio's defense counsel. There's a couple of other pieces of evidence, and these were police reports. Is there a way that I can get to the desktop of this computer? Is it all right if I just want to click on a couple of these? Will it pull up? Thank you. This will be a little bit hard to read, but I want to show you a couple of pieces. Wow, there's no way you can read this. The open file, while I'm getting this ready, the open file policy was followed in Joe's case. And that open file policy is consistent with what you've heard here today. And we got Joe's defense counsel to testify at the habeas hearing. That open file policy consisted of sitting in a room and having the police detectives, the prosecutor, read from police reports that they had in their files. And luckily, Joe's defense counsel kept copious notes about what was revealed to him by the prosecutor during Joe's case. He went back in his archive files and found those notes. So we were able to look at the discovery that had been provided by the prosecutor and police department and compare it to what Joe's counsel was told by the prosecutor. And this is one piece of evidence that was not provided. You'll see at the bottom, this was a police report that was in the Klan homicide investigation file. At the bottom it says, received a cassette tape of conversations between informant of a particular detective and Anthony Creamy, who was incarcerated in jail at the time, which may incriminate others in this crime. This tape attached to this file. Joe's defense counsel was never read that paragraph, and that tape was never provided to Joe's counsel. We investigated and tried to find that tape. The tape, according to the logs of the Cleveland Police Department, was checked out by the Cuyahoga County Prosecutor's Office in 1988 and has never been returned or found. That was one of the pieces of evidence that was not turned over to Joe's counsel. I guess if we were doing a test about whether that's Brady or not Brady, I think that answer is pretty clear. Another piece of evidence that we found during the discovery were some handwritten notes from the police files. I don't know if you can read these notes, but it says, bloody clothes in Keenan's garage. Underneath, it has Joe, 6'2", which Joe is 6'2", Eddie, 5'9". And this document was never provided to Joe's counsel or read to him. Nor were the bloody clothes, at least to our knowledge, ever investigated, and certainly they are gone now. And Joe's counsel was never made aware that police knew that bloody clothes existed in Keenan's garage. But at the very least, police knew that they did exist and that they would have mattered because of the height difference between Joe and Ed Espinoza, who was the person who provided the alleged eyewitness testimony. That's item number 2. Item number 3, in addition to the others, was this very lengthy police report. But this information apparently wasn't read to Joe's counsel. And this is where it says, we learned from Linda, who was a barmaid, that an incident in her bar occurred last Thursday night. That's the incident, the supposed continuous series of events that led to Tony Klan's death later that evening. She talked about the fight, the fact that they were in on a Thursday night, that they had problems and were eventually kicked out. She added that the victim had come into the bar with a male that she knows is stony, and the only one she has seen since the problems that night was Tony Klan, when he came in Friday evening, the next night, and borrowed money from her. So Tony Klan was supposedly killed after a continuous series of events that arose from a bar fight, yet this information suggests that Tony Klan was alive and well the very next day that he was supposedly murdered, after he was supposedly murdered. This information was not read to Joe's defense counsel, nor was it provided. It's not surprising, I don't think, that we won the case in front of Judge O'Malley. I can't think of a better test case, a better case study about Brady evidence than Joe D'Ambrosio's case. And that's why I fully expect it to be affirmed on appeal. But I tested the evidence on a buddy of mine, and I'm not going to name him, but I was telling him that I worked on the D'Ambrosio case, and I was telling him about the facts. He said, oh, yeah, I was in the prosecutor's office when we prosecuted Keenan. He says, oh, yeah, that guy's guilty, for sure. There's no question about it. I said, really? I said, well, did you know that a couple of police detectives said that the murder didn't occur the way the eyewitness had said? He kind of shook his head. No, I didn't really know that. I said, well, did you know that actually Tony Klang was alive the day after that he was supposedly killed? He kind of shook his head and said no. And I said, did you know that there was a tape that existed that supposedly incriminated others in the crime? He said, no, I never really heard that either. And I said, did you know that the guy who was leading the police around for the investigation actually had a motive, an opportunity to kill the kid? And he said, no. He said, but I still think he's probably guilty. Probably guilty. I told Joe that when the decision is affirmed and he is released, that I would go to bat and try to get an award named after him for being the most patient, innocent death row inmate in the history of Ohio. I'm glad I had a chance to talk to all of you folks today. I hope you enjoyed the presentation. Thank you very much.
Well, ordinarily, I would open things up for discussion, but and questions. This has been a very long day, and I think that we probably have taxed your patience long enough. I do want to make a couple of comments. The first to Mr. Lewis is perhaps we should take some pride in the fact that Judge O'Malley is one of our most distinguished alumni. The second is, I introduced myself earlier as an associate dean. I think more significant for our purposes, I have the privilege of being the advisor to the law review, and I want to take this opportunity on behalf of the school to thank the editors, particularly Steve Day, the Symposium editor, and Liz LeBlanc, the editor-in-chief, and I want to turn things over, but before I turn things over to Liz, I think they all deserve a round of applause. And having said that, let me turn things over to Liz to wrap up.
Well, I'm just going to conclude really briefly because I don't think there's anything I could possibly add to such a wonderful day. But I want to really wholeheartedly thank all of our speakers and panelists for joining us today. And thank you all for attending. And there is a reception right outside in the rotunda where you can ask, hopefully, our speakers a few more questions if you have, and talk about all the great things we talked about today. So thank you. And yeah.